This is going to be the last recording of the evidence outline on the last topic, Chapter 11. Chapter 11, Authentication and Best Evidence. Real evidence or physical evidence not require a party introduce the best evidence available on every given point, but that to prove content of a document, the party seeking introduction of the document should produce the original with exceptions. Demonstratable evidence, not subject to either authentication and best evidence, is best evidence is authentication is party offering the evidence must provide sufficient evidence to allow fact finder to conclude physical evidence is genuine. Conditional relevance. Distinguish introducing an exhibit and marking an exhibit, which is physically labeling it. Into evidence. Which cannot be used by a jury in deliberation. To be used by jury. Authentication, FRE 901, 903, CEC 1400, 1454. Advisory Committee Note to FRE 901. Authorization is an inherent logical necessity. Example, identity of party of telephone call. Testimony from person with personal knowledge to lay foundation. The best evidence rule. Historically only admitted best evidence on particular question, but is now a shadow of its former importance. Scope and purpose. Langbein, historical foundations, 1996 treaties. Jeffrey Gilbert's treatise, The Law of Evidence, published 30 years in 1974, subsumed all rules of evidence written, unwritten, under best evidence rule, oriented to authenticity. So my initial notes on this are actually really confusing, just because they're like in the top margin. So when you read them straight through, it's that demonstrable evidence. I just don't know how that fits into either authentication or best evidence, or maybe it's a little of both, but and maybe they fit into it. But demonstrable evidence not subject to either authentication and best evidence is real evidence or physical evidence is what I threw together. And then best evidence is not required, does not require a party introduce the best evidence on every given point, but that it prove that to prove content of a document, the party seeking introduction of the document, the party seeking interpretation of the document should produce the original with exceptions. Authentication is party offering the evidence must provide sufficient evidence to allow fact finder to conclude physical evidence is genuine. Conditional relevance is kind of a subpart thereof. Distinguish introducing an exhibit into evidence to be used by a jury and marking an exhibit, which is physically labeling it, which cannot be used by a jury in deliberation. And then we went into authentication and best evidence rule, and that was a little bit more clean. With some treatises we went into now. Reading further, which is again in the margin and tough to read, but rarely applies to ordinary photos because supporting testimony accompanies photo to determine if proper and to admit. Motion pictures. X-rays from medical records under FRE 803. 6 as BR. National Archives, tax return, reproduction are considered originals. Advisory note to FRA 1001, 2. Substantial guarantee against fraud, inaccuracies, but many alternatives evolve to reduce the need for best evidence. Content sought to be proved. Non-documentary, even though there is a written copy. Written copy. Nance, treaties, Nance, Meyer explains problems with Gonzalez Benitez case. Explains. Myers applies to documents only for content to be proved. Treatise. Exceptions. Advisory Committee notes to FRE 1003 8 secondary evidence hierarchy preference. Counterpart, substitutable for original to describe content if no issue about accuracy and genuineness. (1003) doesn't require original if there is no genuine issues as to authenticity. 1004, production of original for proof of contents has developed as matter of preference. No explanation needed for failure to produce original if it's a public record due to inconvenience to public and custodian. Which is why they tend to be authenticated by stamp. FRE 1008 promotes a Judge 104 decision on 1004 to the jury when it is a threshold question. Dispute about contract. Dispute when original isn't available anymore. Right, we're going to skip another 1,000 cases on this topic that I briefed. And, okay, so Myers, that's a case. So we're going to want to talk about that case right there. And Gonzalez Benitez is also a case after that case. So I want to make sure to get in the right place. But I know there's one more page of book notes about physical evidence. New section. Physical evidence. Demonstrative evidence. three-part concept developed in absence of specific rules. Things. Assertions of things by hearsay declarant. To clarify role, actual or direct part in incident or transaction giving rise to the trial. Direct role of objects are real or original evidence when supported by foundational testimony. Objects that don't play a part in the history of the case, but are tendered for the purpose of rendering other evidence more comprehensible for trier of fact, are illustrative models. Source not significant. Pertains to maps, photos, charts, drawings, article, only requires that item is sufficiently explanatory or illustrative or relevant testimony. Court discretion over benefit to trier of fact. Treatise. Demonstrative evidence development from advent of photos. Not to prove witnessed testimony accurate. Not independent or corroborative evidence. Just visual representation of testimony. Brain treatise. And that's actually it. There's just a lot of cases left to brief from this chapter. I'm going to do that. I'm going to do that now. Just don't know if I'm going to do it all aloud. I did look at the Trammell case and the Rule case, and the Jaffe versus Redmond and Enri grand jury case under seal in U.S. Okay, so beginning probably with authentication of evidence, you have U.S. versus Long. I don't think I can do this out loud anymore.